Welcome once again to my channel. In today's tutorial session, we are basically going to talk about the law of tort. And specifically, I want to talk about the tort of forced imprisonment, what entails within the tort of forced imprisonment, and what does it require to prove in court when you are alleging the tort of forced imprisonment. Once again, my name is Imprisonment Alex. Please, I encourage you to subscribe and share with your friends as we embrace the art of learning together. So, what is forced imprisonment? A forced imprisonment is basically the circumstance where a person's motion is restrained to any direction. A person is not allowed to take any motion to any direction. That is basically what is uh, forced imprisonment means. When we talk about forced imprisonment, this does not basically mean that you should be in the prison. When we talk about forced imprisonment, it does not basically mean you have to be in prison. I must repeat, it does not mean you must be in prison. At any place you can be forcibly imprisoned. A person can imprison you from your own house. A person can imprison you from your own room. A person can imprison you from workplace, office, even outside in the playground. Someone can forcibly imprison you from that place. So basically, to that effect, you must appreciate the discussion in the book of John Cook on the law of tort. He critically discusses the law of forced imprisonment. So, for you to allege forced imprisonment, you need to know that the person who committed that tort must have restrained you from taking any direction. And you must show that actually you had no any means of escaping. The moment you have any means of escaping and you didn't use that means, the means available, then the claim is likely to fail. You have to appreciate the case of Meering versus Graham. Meering versus Graham, uh, it's Meering versus Graham Aviation Company Limited. It's a case of 1920, 122 LT at page 44. Rod Atkin observed it well that a person can be falsely imprisoned even when he or she is drunk, even when he or she is asleep, even when he or she doesn't, when that person is unconscious. That person can be falsely imprisoned. That is according to Rod Atkin in the case of Meering versus Graham Aviation, Graham White Aviation Company Limited. It's a case of 1920, as I earlier said. In that case, basically, in that case, this was an individual who worked for the company, and they suspected of him to have stolen. So the two policemen from the very company approached him. They asked him to escort them to the office, to the company office. So when he reached that, when they reached him, he said, "Let's take the shortcut." He even told them, "Let's take the shortcut." Of course, he didn't know that they intended to arrest him. He didn't understand anything because he was like, "Let's go escort us to the office." But for them, in their minds, they knew that they are doing this in order to keep him in one place so that he does not escape. That was basically the intention of calling him. He told them, "Let's take a shortcut." They indeed took the shortcut. So when they reached at the office, they told him to remain at the waiting room. Then for them, they remained outside standing. So he went to court later on and alleged the forced imprisonment, and that is when Rod Atkin came in to give that verdict. Of course, you need to know that the general principle here is that for you to allege, as I earlier said, please note, as I earlier said, for you to allege forced imprisonment, motion must have been restrained in all directions, and you must have had no any means of escaping. That is basically what it means here. You must have had no any means of escaping. Basically, that is what it means. You have to go and appreciate the case of Murray versus Ministry of Defense. It's a case of 1988, WLR at page 692, where court critically observed that the tort of false imprisonment is not committed unless motion is restrained in all directions. And it is also must be proved that you didn't have any means of escaping. That if you had any means of escaping, then the claim will not succeed. The claim will not succeed. I want to take you back to the case of Meering versus Graham White Aviation. In that case, the respondent argued that Meering, that the plaintiff had the means of escaping, but he didn't intend to escape. That means, if you observe it very well, that means the claim had to fail. That he had the means of escaping, but did not go. That he didn't intend to go. That is the point that Rod Atkin tried to espouse. Hmm? So you must be critical in this regard, that when you're bringing an action for false imprisonment, then you must prove critically those elements I've said. One, that motion was restrained in all directions. Two, that there was no any means of escaping. Three, you must also show that the defendant was the cause of the tort. That is very, very important. Of course, you must prove that actually the motion caused the injury, caused the damage, which is also important in that regard to prove. So otherwise, please take time and appreciate that tort, because these are common law torts, but still in Uganda they apply. So the moment you appreciate it very well, then you are good to go. Otherwise, thank you so much once again. Thank you for watching. Share with friends. Please subscribe. We learn together. Thank you.